Yes, we have spousal privilege in the state of Florida. There is no parent-child privilege. In fact, most states do not recognize a parent-child privilege. Most federal courts do not recognize a parent-child privilege. So again, my job ethically is to do everything we can within the bounds of the law to obtain as much information as possible about this case.
We've heard this is very rare. I want to know from the We've heard this is very, very rare. That this rarely happens. So
investigative subpoenas are used frequently throughout the course of our investigations and prosecutions.
But to the parents, but to seek an investigative subpoena against the parent, we've heard that.
You've heard it incorrectly. We use investigative subpoenas, again, frequently. And in this case, like any other case that's a capital crime or a case of this magnitude, we're going to use every avenue at our disposal to obtain the most available evidence that we have to determine what happened to bring prosecution against the defendant. Well, I can't talk generally. I can't get into strategy, as I've said before. We're going to be as transparent as we can. But I can't say anything that's going to undermine the integrity of the process. Generally speaking, however, we want to talk to any witness who may have information about what happened on the nights in question, about the defendant's whereabouts, about the defendant's motivations. So those are the questions that we're asking any witness who we believe may have relevant information about the case.
Mr. Ward, is there any indication at this point that the suspect in this case has any sort of mental illness?
I can't get into that right now, but as I talked about the other day, we're going to conduct a thorough evaluation of all the statutory aggravating and mitigating information with regard to making a decision about the death penalty, and the defendant's history of mental illness is one part of that process.
Speaking of the death penalty, what is your opinion on that at this point? Is that wavering at all?
Absolutely not. If there's a legal basis to seek the death penalty, and it's consistent with the wishes of the victims' families, we intend to seek the death penalty. We're going to speak with the victims' parents, the victims' families throughout the course of this process to help them understand what's going on and to talk with them about how the prosecution is going to proceed, including their thoughts about the death penalty. This is not a one-time event. This is going to be an ongoing process in the coming weeks, months, and years.
I believe you've spoken in the past, and I don't have an exact quote, that age and mental health are huge determining factors when it comes to the death penalty. So what do you say about this case if mental health is an issue, and what do you say about the age as well? This defendant is in his early 20s.
The defendant's age and history of mental illness are factors that we are statutorily obligated to consider. They are not the most serious of mitigating factors or the least serious. We take it cumulatively with what we're required to evaluate, and we'll evaluate those two factors along with all the other mitigating information that we have.
So we've heard from sources that you have an airtight case.
I'm not going to comment on the strength of the case at this time. Please understand that no charges have been filed yet.
And why is that? Why hasn't there been an
Because we need to bring an indictment before a grand jury. So I'll be happy to explain Florida law a little bit. In Florida, you cannot charge someone with a capital offense through an information. It has to be an indictment returned by a grand jury. Our grand jury sits for 6-month terms. They sit usually once a week. When we have 21 days from the date of arrest to return an indictment, and we'll be doing that within the 21-day period.
Are you doing that tomorrow?
I can't comment on when we're going before the grand jury. The grand jury deliberations and proceedings are secret.
It's my understanding that not all 4 families of the victims agree in the same way on the death penalty. So how do you approach that? How are you going to handle it now?
Well, it's a conversation that we have to have with the families. And again, it's a conversation that happens over time. There's an evolution with dealing with the victims and victims' families in cases like this, where we want to make sure they understand the process, what goes into it, make sure that they're giving us their best opinions and recommendations about what they think the sentence should look like.
Sir, how much do the victims' families play into that on whether or not
It's one factor that we consider. And it's an important factor that we consider, but it fits in with the other statutory factors that we're obligated to evaluate.
Do you think somebody has to have a severe mental illness to commit multiple murders like this in such a methodical way? What's your opinion on that?
mental illness, in my view, and in my role as the state attorney, is to evaluate whether someone is competent to stand trial, and in a capital case to determine whether mental illness played such a role in the commission of the crime that it's a mitigating factor against seeking the death penalty.
With Donaldson's parents and immunity against being prosecuted for answering questions, what do they have to lose for not talking with people and sharing information, if they have it?
Again, I can sympathize with the parents of a defendant, especially a defendant who has been arrested for 4 murders. But as you pointed out, the parents do have immunity, just like anyone would who's given an investigative subpoena. So anything they say can't be used against them, which means that a judge will likely compel them to answer questions that are relevant to the investigation.
So the parents' attorney, though, has said that if they do not answer those questions, they could face contempt and even end up in jail or beyond.
I don't think it's going to come to that, and we're not at that point yet. We've filed a motion for an order to show cause so that the parents have an opportunity to explain why they declined to answer questions in front of the judge.
Is this common in criminal cases where the family members of the defendant refuse to?
We deal with reluctant witnesses regularly in all sorts of cases in this community, and frankly, it's a difficulty we have in prosecuting cases. However, with people refusing to answer questions, that is a rarity, because most people understand that they have a duty to understand questions, and when it's explained, when that duty is explained to them by a judge, they're willing to provide answers to us.
Sir, but your family attorney, Ralph Hernandez, has said that this is the family values trial. It's basically asking parents to testify against their own child, so obviously ethical dilemmas. Can you comment on that? Or can you express your opinion?
Sure, and to be clear, no one's been asked to testify to anything. An investigative subpoena has them come in and answer questions in a private environment as part of the investigation. Mr. Fernandez and any other lawyer who's dealing with the civil side of this case is doing the best they can to represent their clients. But as the state attorney, my duties and my obligations are different. We are here to investigate and prosecute this crime to hold the defendant accountable for what he's done.
When you said it would not come down to the parents wanting to live or being fine, but that is a possibility, from what I understand.
It's a possibility under the law, but again, we're not at that point in the process yet.